Lisa.
You're not
Mike
meeting
Carroll,
me?
nice to meet
I
you.
grabbed Taylor for a little bit, but I'll come back for the end, obviously. Awesome. It's awesome. All right. I would like folks to come on in. I know we'll have more coming in as time goes on. The welcome here has multiple generations, really, because we have some of our early folks who graduated Colorado Law and have made a mark in the cable sector. And Nikki Tuttle and Alan Singer are two of our real standard bearers. Both have had fabulous careers. We have more recent alums who were part of the Silicon Flatiron Center here. Nikki and Alan only could have imagined what such a center would look like. Todd Hoy at one point was doing our media and communications, and he is now working for Stars. He's here. John is here. For people who don't know, we had a great, really a unique thing, which is two Colorado Law grads testifying for Congress in the same panel. Allison Mania and John Bergmeyer were both testifying. Allison couldn't be here, unfortunately, today, but John is here. We have our newest arrival, Cristelia Garcia, who honestly is a true content person. So unlike Paul or I, or Harry or Blake, who kind of fake it a little bit, she's the real deal. She knows licensing from the inside and out, and she joins us and will be helping develop a content initiative here at Silicon Flatiron. So this is sort of, in effect, the beginnings of more to come. And we thank our friends from Cablevision who are sponsoring our reception and who I have a great deal of affection for. A little known fact about my career is that after I left the Department of Justice for 5 months, I worked with David Allen and Lee Schroeder at Cablevision, and it was a blast. For people who don't know Cablevision, or know them only from the outside, it is a special, special culture and community, and my experience there really was exceptional. Dave is one of the smartest lawyers I know, and he inspired this conference, I believe, a year ago. We were at a reunion together where he said, listen, this Aereo case is really fascinating, but let me tell you, it's really all about cloud computing, and the risk is that the Supreme Court will decide this case in a way that Aereo might lose, and it will have all sorts of unintended effects on cloud computing. And he, of course, was thinking about his Cablevision DVR case that he pretty much masterminded. And there were some academics who were more skeptical of that proposition, others who were more, I think, let's say, sympathetic. But for David's standpoint, the Solicitor General is sympathetic, so that's worth something. So today's conference comes at an opportune time. Aereo has been argued. It's now pending. And a little known fact, it all kind of, from our sort of perspective, started here because Barry Diller announced Aereo and his commitment to invest it at our annual conference here about, I think it was 2 years ago or so. And Barry Diller has since quoted, since written op-eds about the case, so you can go look what he has to say. I will just have a few more thank yous and then let Paul Ohm actually explain to you what this case is, and we'll get to some of the legal issues involved in it, and then we'll get to some other legal issues that are relevant. And finally, we'll take a look at the business environment to bring things to a close. With respect to thank yous, my job would not be complete without thanking both Anna and Cactus, who do an amazing amount of work behind the scenes, and we're so lucky to work with. Let's give them a round of applause. And then I want to also acknowledge and give a shout out for a lot of our students who are here today. And a few of them I can acknowledge, as well as a few of them who I will later make introductions for. They're a fabulous bunch. Stephanie Minnick is graduating, is a rock star, does not yet have a job, so feel free to talk to her. She's pretty committed to working in Washington, D.C., which is not hard to do in this space. We have some people going to Washington, D.C. this year. So Coben back there will be working at AT&T this summer in Washington. And John Cook is staying here in Colorado working at Dish. And I know we've got some folks outside as well. So when we get to the reception, I'll make a special plea to engage with our students. And as Paul will remind folks, we have a rule here that they get to ask the first question. So with that, I'll turn it over to Paul Ohm. Great.
Thanks, Phil. My name is Paul Ohm. I'm a member of the faculty, and I help direct the Silicon Flatiron Center. Phil invoked his what we now affectionately call the Wiser Rule, which is at the end of the panel, the first question will go to a student. But this is the first time I've done one of these so close to graduation, so I'm not sure what to do with these people who graduated 4 days ago. Hopefully some of your downstream classmates will save you from having to have me do statutory interpretation. Okay, now on the topic of statutory interpretation, it's a little unusual and atypical for us to have a conference where 2/3 of it really does revolve around a single case. And not just any case, but a really, really complicated case. And so I quite unwisely told my panel, whom I'll introduce in a second, that I was going to start the day by giving you a quick and dirty overview of this case. And so yesterday I sat down at 3 p.m. to create a PowerPoint, and I'm not a PowerPoint guy. And 2 hours later I thought, this was stupid, but I've got to finish it now. So hopefully, especially for the students in the room who haven't had copyright, this will be a good overview, a gentle introduction to the case. And hopefully the panelists will watch me closely and keep me honest, because I'm not a copyright scholar. First and foremost, I'm likely to make some mistakes. So this is spot the mistakes. So let me try and do this in 20 slides in 5 minutes or less. Let's see if I can pull this off. So this is a copyright case. So we need a representative work to talk about. I've been obsessed of late with Doctor Who. I've caught up with all of the Doctor Whos. And I thought it was appropriate because Doctor Who is probably the only show right now being broadcast that was being broadcast at the time of the original facts in this case, the predecessor cases. So there's my picture of the 12 doctors. We can, during Q&A, talk about which one we like the best. But this is a copyrighted work. There are copyright owners involved in it. In fact, with something as complex as a television program, there might be multiple copyright owners. Copyright owners are extended different rights in Section 106 of the Copyright Act. And the one that's really relevant for this first panel is you have the exclusive right to perform publicly the copyrighted work. Public performance is what this case and this panel is all about. What does it mean? Well, in the traditional sense, it used to look like this. A television broadcaster would take the copyrighted work, send it through the airwaves, over antenna, and it would appear like magic on televisions, distributed in a pretty localized region. Okay, this is traditional broadcast. So that was from the early days of television, where things began to get complicated and where we started to take the road to Aereo. And really there are two branches that led to Aereo. This is branch one. Was with the invention of something called community antenna. The idea here was, here we have the televisions on the right. They're probably in close enough proximity to the broadcast tower to receive the signal, but there's some obstruction that's preventing them from getting a good signal. For example, a mountain range, pretty appropriate here in Colorado. So what you do is you erect an enormous antenna on the side that can get reception. You run a cable across the barrier, and then you can do one of many things, but one thing you do is you set up a new tower and rebroadcast or retransmit the signals. So here's our Doctor Who. And by the way, this animation is the absolute outer boundaries of what I can do with PowerPoint. Let's watch that again. That was really impressive. Through the air, over the antenna, down the wire to the second tower, and then it gets rebroadcasted. Okay. But we're faced with this question, which is this implicating a copyright of the copyright owner? Is this something that requires permission and a license? And when this started in the 60s, this was the question, and there were lawsuits, and you'll see in a couple of slides, this went all the way to the U.S. Supreme Court, however, under the prior version of the law. So that's community antenna. A variant of it was cable television. There probably are lots, and there's cable people who know this so much better than I will ever dream to. But one of the differences here on the right side of my diagram, you have an infrastructure, you have cables distributing this. But the more important distinction, at least as presented to the Supreme Court, was this. You could receive the signal and then send it hundreds of miles, in the Supreme Court case, 450 miles, to a second place that would not have been able to receive the signal originally, mountains or no. Okay. And so these were the questions presented to the Supreme Court in two cases in the late 60s, early 70s. Here they are under fortnightly. And remember, this was the old statute. Under fortnightly, the Supreme Court said community antenna is not a performance, right? Whatever it is, it's not a performance. Under teleprompter v. CBS, cable TV is not a performance. Probably also not a public performance, but not a performance under the 1909 Act. Okay, flash forward a couple of years, Congress responds with the 1976 Act, and we're still living basically under these provisions of the 1976 Act, and make it quite clear and explicit in the legislative history that they intend to capture cable TV and community antenna within the public performance right. How do they do this? And again, I apologize for the statutory text. I have the feeling these people on this first panel are going to want to talk about some of this text. Well, first of all, they define perform, which means to recite, render, play, dance, or act it either directly or by means of any device or process. To show its images in any sequence. That sure sounds like what community antenna and cable TV do. You should know, by the way, that device or process is further subdefined in a way that says technology is now existing or to be developed. So they're trying to future-proof it. But more importantly for this case, they then have to address what does public mean in public performance. And the Supreme Court has these two paragraphs, and the second paragraph is what's really at issue in Aereo. The first paragraph says, when I teach copyright, I call this the friends or family clause. If it's in a space that's totally open to the public or one that's beyond friends or family, normal circle of family and social acquaintances, that's a public performance. But look at number 2. To transmit or otherwise communicate a performance or display the work to a place specified in clause 1. To transmit a performance becomes an implication of the public performance right. And again, I think some of the people on this panel can give you great lengthy dissertations about multiple words in this provision. In fact, I'm going to leave it up at the end, and it could be the backdrop to our discussion. Okay, that's branch 1. I'm more than halfway there. I think I'm doing okay with time. I'm going to be a few minutes over. Branch 2 is much more familiar to lots of people in the room, even people who don't do copyright for a living. Sony v. Universal from 1984. Why does this become important? We'll get to that in a second. What is this about? This is about the fact that television signals arrive on your TV, and then if you're not watching, they disappear. And so in the late 70s, Sony invents this thing called the Betamax. I love that picture of it. I never had one like it, but I wish I did. And what does the Betamax let you do? Of course, it lets you not be present during the initial broadcast. You can save a copy of the television show. And when you save the copy of the television show, you've done what copyright scholars and academics and practitioners started to call time shift. So now you can watch this show later on. Sony I think I took out the slide. So the way Sony is concluded is the content industry decides not to sue the masses for hitting the record button, but instead they decide to sue Sony for creating and distributing this device that they said created secondary liability, not direct liability, for basically empowering the masses to infringe copyright. Notice, and this is something I want to talk about on this panel, notice that by suing Sony for secondary liability, the theory really isn't that Sony's performing anything. It's that Sony is giving people the ability to reproduce copyrights, right? So the public performance thing doesn't even come into Sony. You might be asking, well, then why are we talking about it so much? After Sony, we then have lower court cases that make it clear that Sony survives lots of technological upheaval. So if we switch from the Betamax to the modern TiVo down there, Sony still applies. If we add cable instead of over-the-air broadcast, Sony still survives. The bottom line is that customer is the one buying the device and pushing the record button. That is a fair use, as our second panel will discuss. And the time shifting is a fair use. Sony is not liable, and there's lots of other things we can say about this in the second panel. But, this is where things get complicated, if you thought they already were. So then we get to Cablevision, a cable provider, and Robert Cry is on our first panel and helped represent them in every phase and represents them still today. What did they do? And this is probably where I'm going to get this wrong, and you can correct me. As I see it, at least, they miniaturize the DVR, the TiVo. It's not actually TiVo branded, but I was too lazy to look for other clip art. They take it away from the 1 foot distant from your television and instead transport it into the cable television infrastructure upstream. And here's where they started to get really, really clever, and I don't know if this was good lawyering or accidental engineering, but they essentially in software created a kind of your own personal DVR for every one of their customers that was remote controlled over the cable system distant miles away. So I have 3 little TiVos floating there in the cloud. Now when Doctor Who is broadcast and sent and retransmitted and whatever, and it lands there and you, the customer, say record, what it does is it creates a separate recording for every one of the little TiVos in the cloud, enabling every one of you to time shift. Critically, Cablevision gets sued before they can even launch this service, this TiVo in the cloud. Again, that's not what they would call it. And the Second Circuit reverses the district court. And the Second Circuit says this is not a public performance. But one critical subtlety to get is that in this case, Cartoon Networks, the plaintiffs, sued Cablevision as direct infringers, not as in the Sony case, as secondary infringers. Why is this important? Because suddenly we're faced with the collision of the two branches I've just presented. We're faced with the collision of, is Cablevision, by giving you the ability to store TV shows and then replay them at a different time, is Cablevision now acting like community antenna? Are they now publicly performing this work in all of your living rooms? And the Second Circuit very interestingly says no, and this is the deepest we will descend into the complexity of this case, so hopefully you're still with me. These are direct quotes from the Second Circuit opinion. The fact that the statute says capable of receiving the performance instead of capable of receiving the transmission underscores the fact that a transmission of a performance is itself a performance. Because their TiVo-like system is designed, only makes transmissions to one subscriber using a copy made by that subscriber, it's not a public performance. It's a performance probably, I think Robert would concede, but it's not a public performance because it's your own private little DVR. It's your own private Idaho, if you remember the movie reference. You created that performance, you transmitted that performance. Sure, it's a performance, but it's only going to your living room. And then your neighbor next door who has the exact same service, he has his own little private performance going on, but he doesn't have a public performance. And 1 million customers across the region can have this, and they're all doing their own little private performances. There's no public performance here. Cablevision is not liable. Second Circuit ruled. Okay, this finally brings me to Aereo. I'm intentionally not going to represent too much the facts of Aereo. I'm just going to put up a few slides because I'm going to leave it to these gentlemen to do that. This is Aereo. Justice Sotomayor referred to the antenna with the dime, so clearly she had been shown this picture at some point. They manufactured a tiny TV antenna that looks just like this and is this size, and then they found a way to engineer it onto boards that look like this. And so what Aereo is trying to do is really take advantage of the reasoning of the Cablevision. Instead of giving you your own private little DVR in the cloud, they're giving you your own tiny little television antenna in the cloud. And oh, by the way, they're attaching DVR-like capability to it. So here's the last thing, and this is where I'll probably really do gross misrepresentations. I think the broadcasters want you to think it looks like this, the world. Right? I'll do that again. Aereo is basically the big antenna, even though there's lots of little ones, and then they're doing a public performance to the rest of the world. I think Aereo would rather you think of it like this, where they're basically creating your own private little retransmission party for private purposes. We get to the Supreme Court, and the Supreme Court is now asked to decide, is this in fact a public performance? Is Aereo publicly performing or not? And I guess I'm rushing through this so quickly. I do want to say, what's at stake here? What's at stake here are cable cutters, cord cutters, people who don't want to get cable television service, even though they don't mind broadband internet service, but are a little afraid to lose all the local broadcast channels and don't want to go out and put an ugly antenna back on their television. They want to pay Aereo, what is it, like $12 a month for the privilege of having tiny little antennas in some room they've never seen, send the local channels to them. Okay. Now step aside. Let me see if my microphone works. We good? Can you guys hear me? All right. So that's the introduction. We have a tradition here at Silicon Flatirons of not going into length with the biographies of our speakers. It doesn't quite do them justice, but it's why we produce them for you in the program. But I will briefly say Michael Carroll joins us from American University, Lance Kuntz from Davis Wright Tremaine, Robert Cry from Molo Lampkin, and I've already mentioned has signed a lot of briefs on behalf of Cablevision in a lot of these cases, and Dave McGowan from the University of San Diego. Actually, can you put that back up, Rex? I promised I'd leave this up. At least, yeah, maybe on the wings. Okay. So that's the provision I think we're going to talk about. So I guess, one thing I say at the end of these conferences is I like to kind of decide for myself if I've learned something. And that's the only way I can judge whether we've done a good job, because I'm too self-centered to think about all of you. I think I'm more confused about Aereo after my presentation than before I started. So I want you to help me clarify for this audience two things. One, what did I get wrong? And two, like, what's the big thing they really need to focus on before we get to predictions about what the Supreme Court's going to do? So I'm not going to ask a lot of jump balls, but let me present that one as a jump ball. Does someone want to kind of answer either one of those two questions? Even if you're just going to repeat something I said, like, what should we underscore for the audience? Michael, you look
All
like
right. Well,
you cleared your throat.
I'll
It's a
take
very
a
long
stab.
professional.
I had to teach this case. So, in the way to think about it is copyright. Copyright gives the copyright owner a set of exclusive rights. Those rights are defined by verbs. So the question in any copyright case is the activity that somebody's doing falling within one of the verbs? So here the verb is to perform. And then the question is, and everyone agrees that a performance is going on when a television show gets streamed over the internet from Aereo's server to the user. The only question is that performance a public performance? And I think, Paul, you set it up right, but the problem with the statutory language up there, right, is that it is a public performance to transmit a performance, not a great form of drafting when you define something with the same term. So that's the source of the initial problem, is you're performing by transmitting a performance, right? And it's that second phrase where it is a transmission to the public, right, by means of any device or process, whether the members of the public capable of receiving the performance or display receive it. And those are that's the piece of statutory text that the Second Circuit and the Supreme Court are going to have to struggle over, because there are essentially three layers that you can choose from. So capable of receiving the performance? Well, that could be, if it's a television show, is it the performance of the actors on stage while they were being filmed? Is it the work of authorship? And the Second Circuit said if you define it that way, then there is no such thing as a private performance, because all members of the public are capable of receiving the copyrighted work in some shape or form. Right. So that doesn't work. So then you could say, well, the recording of the performance, anyone who's capable of receiving the recording of the performance, it's to the public. But that's everybody again. And so as a result, the Second Circuit said, even though we know that the performance in the first part of the phrase is the work of authorship as it's being recorded, in the second part, it's who's ever capable of receiving the data stream of the transmission of the recording of the work of authorship. And because it is one copy for one customer under Aereo and under Cablevision, the audience capable of receiving that data stream is an audience of one. That's a private performance. So that's the reasoning below.
Yeah, and I neglected to say that. So District Court and Second Circuit both find for Aereo on this question, right, that there is no public performance.
But I think it's important to recognize the Second Circuit felt forced into that position to some extent, because otherwise the words to the public get read out of the statute. Because if it's anybody who can receive any copyrighted work anytime, any place, right, then everything's a public performance. So the cloud piece is, how do you read that language? As I was at the argument, and I think the justices, you never can take too much away from their questions, but there was a clear sense that they want to write an opinion that holds Aereo liable for public performance, but holds services like Dropbox or other cloud storage companies that transmit data to people as not publicly performing. But we're just talking about data streams from one server to one computer. And so how do you write an opinion that translates or interprets that language to treat Aereo's data stream different from a Dropbox data stream? And that is what's going on in Chambers.
I was told on your last comment, and I want to get to that in a little bit as well, but I was told by a Supreme Court litigator friend of mine that be careful, you're about to break the economy is always a really good argument in the Supreme Court. And they're very, very worried about that. And sure enough, it shows up in Aereo's brief, and also lots of the amici make the argument that if you're really going down this road, you're getting close to Dropbox and other business models. But before we tee up the cloud question, let's finish. I think you did a very nice job kind of saving us from the depths of how far I felt at the time. Anything else to add that you really want to underscore here? Lance, you were nodding during part of that.
I'll jump in on that.
Okay.
When you're looking at this statute, I think there's both a text question and a context question, and it's important to consider both those things when assessing the legality of services like Aereo. I would, the key phrase in the transmit clause is definitely to the public, which means are you making something generally available to anyone that wants to sign up for your service, your entire subscriber base? And then that raises the question of when you talk about transmitting or otherwise communicating a performance of the work to the public, what are you talking about? Are you talking about the prior underlying performance when the actors performed on stage 5 years ago, or are you talking about the performance, the showing that's created by the act of transmission? And so a basic part of what the Second Circuit did in Cablevision was that it's the second of those two things. And I think I would just disagree with you on one point. I think what the Second Circuit said is that the performance throughout that clause means the performance created by the act of transmission, so that when Congress says to transmit or otherwise communicate a performance of the work to the public, they don't mean you take some old performance and transmit it. They mean you perform something by means of a transmission, so the performance is what's actually coming out. And the consequence of that choice is pretty important, because that means that what you are focusing on when you look at the people capable of receiving capable of receiving the performance, is the showing you're creating by the transmission. And so that's why, for example, with video on demand, that's a public performance, because anyone can sign up. You're totally indiscriminate as to who's going to play that next show off your system and watch it by transmission. So that transmission is being offered to anyone that wants to receive it. By contrast with the cloud service, with Amazon Cloud Player, the only person that's getting it is the one person that put that particular.
But let's be clear on the video on demand. Let's just make sure. So you're saying that you have a single copy of it. Does that become important in the video on demand hypothetical that sits on a computer server somewhere? And when someone uses your, by the way, very hard to use user interface and says, I want to play that movie, I'm not you in particular, that it then gets transmitted, and because that can happen to multiple people, that becomes a public performance.
This is a very important point, because I think the single copy is important and it's definitely relevant, but it is not dispositive. And in my view, that's where the Second Circuit really went off course in its second Aereo decision. Okay. In the context of the RSDVR, the fact that you were just talking about a system that lets people record their own shows and watch them later, in that context, the separate recordings really do matter, because they're the same recordings you make on your house with your VCR or your set-top DVR. I mean, that's a meaningful part of the service you're offering. That doesn't mean that you can then take a system that would otherwise be making public performances and just stick individual user-associated copies in the transmission streams, where the content flows through, sits in the individual copy for 3 seconds, and then flows on to the user. I mean, in that situation, it's not changing the fundamental nature of the retransmission service that's being offered. And so I think that while it's definitely a relevant factor that you have separate copies, and it can help you think about what the service is and what you're offering to your subscribers, it's not dispositive, and that was really where the Second Circuit went astray.
And then just level setting here again, and I feel like half the time so before any of this happened, and your client Cablevision was just a cable TV provider, public performance, clearly, right? Under the statute. Yeah, just day-to-day retransmission of things that were broadcast over, that's public performance of someone's copyrighted work, and accordingly under the Telecommunications Act, they've been paying compulsory license royalties
under the Copyright Act.
Yeah. Okay.
So one thing I guess we should do, also level setting, is that the sort of competing view on the statutory language, which has been now really followed by 2 other district courts. So that what's before the Supreme Court is the Aereo case from the Second Circuit, but we've got now these other cases that have been decided the other way against Aereo. You end up reading a little bit of the transmit language out, as Michael said, but the courts have focused more on the overview of performing through a device and doing that generally, and so those courts have taken a much more contextual view, I think, in this case I mean statutory contextual view of the language, and have really looked at the broader question of whether or not the public performance is intended to be by Congress, whether this type of performance is intended to be public under the statute. So I think that we are now in a situation where where the Supreme Court's going to be looking at what the Second Circuit did, but is also going to be looking at what these other courts have done with it as well. And they were clearly troubled by having to sort of choose a direction here, given the cloud services issue.
Let me reset this just a little bit. Before I do that, I have to add one part of my bio that I don't think Phil told Paul. I'm a partner at a law firm called Dury Tongri. We represent a company called Aereo in some cases, not in the Supreme Court. So discount accordingly. Phil called me because I'm a copyright antitrust guy, but I want to reset the bar. The three things that we are talking about are the ability of technology to empower consumers, the distress people seem to feel over entirely predictable cycles of technology, and the degree to which, and this is a jurisprudential question that those of you who just graduated, this is your lives, the degree to which people think there is something wrong with analyzing precedent as a way of running your affairs, which is to say what all of you will do for a living when you leave here. The first thing I just want to point out, we're talking about local broadcast television. It's free. That's the foundation of the Sony opinion. You can disagree with Sony, and I'll be interested to see if anybody here actually wants to do that. But the question you have to ask yourself is, sitting in your apartment, sitting in your house, do I get to take what is free off the air and make a copy of it, yes or no? If the answer to that is yes, we're 99% of the way home. Because the question is now just a question of how efficient should that be allowed to be? We started off back when Unix was being written at Bell Labs in Murray Hill, New Jersey, with big mainframes, dumb terminals. We went through a generation where we pushed intelligence and processing power out to the periphery. And you had laptops loaded up with stuff. And now we're re-centralizing, and we have thin devices, and we've got the cloud. None of that should affect how you think about copyright policy. It makes no sense from any cogent point of view to say that it is okay to make a copy in your living room so long as you spend the money for an antenna on your house, so long as you have the intelligence of the apparatus in your living room with you. Now, Cablevision took that first step. And I will respectfully disagree that what they did, which is splitting a media stream and siphoning some off to a user-specific copy, is any different from taking broadcast television and allowing users to initiate and make a copy. All you've done is take the structure that I think intuitively everybody understands is not a public performance because it's in my living room, and made it more efficient by reducing the necessity to duplicate costs. And from an economic point of view, I would be interested in discussing the degree to which copyright's purpose is to subsidize manufacturers by replicating hardware costs. Because I will defend the proposition that it's
Dave,
not.
I mean, trust me, I want to have the debate at this level too. This is the fun level of the debate. But here are words I heard you say: policy, economics, innovation. You didn't say much about law. Like, are you arguing?
That was my third point, but you cut me off.
I know, but when you got to that point, you said, and any sound copyright policy, as opposed to the particular interpretation of this statutory text, right? I mean, I'm assuming you're saying, no, it's all about the text at the end of the day, but here's how you should interpret the text in light of everything else you just said.
I don't think the text is a tough call unless you want to say that the legality of what you watch in your living room depends on what somebody else is doing somewhere else.
But isn't that true for cable TV? So cable TV you're doing in your own living room, but it's still a public performance.
The intermediate step that Cablevision makes and the intermediate step that Aereo makes is to allow users to initiate the creation of a copy. Now, that leads into the third point, which is how do you design a structure like this, and to what extent do legal inputs matter? There are technical inputs, there are economic inputs, there are legal inputs.
Yeah, and the last question, I promise you, and then we're going to go to the audience toward the end, will be about this innovation meets copyright, because that's really, I think, at the heart of a lot of this. Lance, let me go to you, though, on the issue Michael teed up, which was this kind of really good, in my opinion, strategic move in the Supreme Court to make this about Dropbox and the hypothetical. And again, for those of you who live and drink and eat this case, I'm sorry that we keep going back to 101 for some of the students in the room, I think the issue is lots of people have some sort of DVR system that allows them to record TV shows and then stick them in Dropbox. And then they watch them on Dropbox later. The argument made in a lot of the briefs are if Aereo loses this and becomes publicly performing, then so is Dropbox. And the justices did ask a lot of questions about this, like, are we about to break the cloud?
Right, yeah.
So what's your take on that?
My take on it, I guess, is that I think even if the court were to reverse Cablevision entirely and find that Aereo was infringing, I guess I don't see that necessarily means that you would take whatever the court does with the public performance right here and find that everything that is streamed out of a Dropbox that belongs to someone is necessarily a public performance, because the real question to me is, does the user who has the content in the first place have the right to put it there, And then once they instruct a system like Dropbox to stream it to them, it's now the user's volition as opposed to the third party that's operating the system. And also the third party typically would have a DMCA protection in that case as well. So I'm not sure how much it would really change it practically speaking, but I do understand the concern that if a public performance is defined the way the petitioners here want it defined, that at the very least it's going to raise that question whenever you're talking about the cloud.
And just one little thing you said, if the Dropbox users have the right to put the copy there, presumably even if they don't
Even
have
if they
the
don't
right,
under the DMCA, sorry, so I didn't
so
make that
even
point.
if they're putting, downloading BitTorrents and sticking them on Dropbox, it's still not Dropbox publicly performing the subsequent streaming back.
Can I jump in? And I think the worry is about those different layers of what you're defining. One interpretation that threatens Dropbox is if off of the server, the same work of authorship is being streamed to multiple people. So if there are multiple different copies of the same television show on Dropbox in multiple different accounts, and they go to their individual users, but if the public performance is of the work of authorship, then Dropbox is publicly performing, because Aereo's argument is, I'm sending lots of data streams from lots of copies, just like Dropbox is. And so how do you distinguish those?
So you're not as confident as Lance that they can do no harm, even if they reverse the
I think they can. I think they're going to work really hard, but I think it's going to be difficult. But one other thing about...
Can I just add one thing before we go off that topic? I think it's important to, I agree with most of what you said, but I would point out that even for the RSDVR, all the same arguments applied. And consider a situation where a customer goes on Amazon to their MP3 store and lawfully buys a copy of a song. They download it to their hard drive, and then Amazon also has a separate service where you can upload that back up to your personal cloud player storage space and then stream it back to yourself. And it's certainly possible that 10 different people might all decide to buy the same song off of Amazon's MP3 player, load it back up on the cloud player, and then play their personal copies back to themselves. And that seems like a paradigmatic cloud service, even though the same company is separately providing both the content and the cloud playback service. And I think that maps directly onto what Cablevision's doing with the RSDVR. You have a company through one license service that's making content available through its licensed cable system. Then it also provides a separate service for an extra $10 a month where you can volitionally pick your own program and record it on the RSDVR, where Cablevision offers you the space to do that and then play it back. And then finally, Cablevision gives you the means to play that back later on, but the only person who can play it back is the one that made it. So Cablevision participated in the case certainly because the most expansive versions of the broadcaster's arguments would threaten cloud computing, would threaten the RSDVR. I think as the case progressed, and especially by argument, both the government and the petitioners had backed off that pretty far. So at this point, we have a lot more comfort than we did earlier in the case. But those arguments are out there, and the broadest form of them certainly does threaten cloud technologies, of which the RSDVR is one.
So do we know that Amazon doesn't think it's publicly performing in that situation?
Well,
Are they paying a license? Does their license
not for the
include
cloud,
the
not for the cloud player.
Okay, I just want to be clear on their cloud player business.
Can I just,
Okay.
especially for the students, the way this case got teed up and framed, there are so many other ways in which this case could have been litigated. And so it's really important to understand the importance of litigation strategy, that this was isolating this particular exclusive right and teeing it up as a clean case for the Supreme Court. This case went very quickly to the court. As you said, we've still got other district court. It's still not. We don't even have a circuit split yet, and that's unusual. But it's because of the cleanliness and what clean means is it's a pure issue of law, a pure issue of statutory interpretation. But one way to rule in the way that David suggests, and what's interesting is that this is not in the case, is to say Aereo is not doing the transmission. It is the customer who pushes play that causes the data stream, and it is the customer performing. And what's odd about it is that the Second Circuit held that when the customer pushes record for both Cablevision and Aereo, it is the customer exercising the right of reproduction. But when the customer pushes play, it's the company. And they only assumed it in the Cablevision case. They said, we could try to analyze it as if the customer's doing it, but we don't have to, because even if Cablevision is doing the performing, it's okay. And then when you get to the Aereo case, they just carry that assumption over. So, and then the Supreme Court grants cert on the question of whether Aereo is doing the performing. So the issue of the consumer pushing play and that being the end of the case sort of dropped out.
So I'm going to let you, you look like you want to chime in, Robert. David's been waiting patiently. But before either of you get to go, point of clarification. I mean, it's my understanding, and I might be wrong, that this was an intentional choice by the plaintiffs. That in the way they drafted the complaint, they chose to go on a direct infringement theory, which is kind of what led us down this path. I mean, is that right? Does that sound?
That's true, but I'd just clarify that the issue of who is doing the performing, although not passed on by the Second Circuit, was definitely teed up in the Supreme Court, and the government's brief in particular devoted a substantial amment of argument to it.
But it wasn't in the question presented.
I think they might disagree. I mean, they might view that as being broad enough to cover both
Says
issues.
whether a company.
Right.
Anyway.
So David, on this question on the cloud.
Yeah, no, I forgot one thing about my disclaimer before I say this. I'm not here on behalf of Aereo or my law firm. My faculty would certainly disown me. So this is
I think you
me.
should just say you're speaking for Cablevision.
I don't
Robert
even-
was
I should put on the same disclaimer right here in my personal capacity.
I don't even speak for my 8-year-old, so God, least of all. I want to distinguish, make sure that everyone's got one distinction, because Robert mentioned a licensed input. You don't need a license to use an antenna to grab broadcast television. That's the point of the deal. So the legality ex ante, if you will, is not what's at issue, and it's not really ultimately going to matter specifically in the broadcast television space. The difficulty, I think, that we've been talking about with Dropbox and all of that is an artifact of what I talked about earlier, which is the progress of technology, which has only ever done one thing. Frank Easterbrook said this years ago, and he's right. Since Gutenberg, only one thing has happened to the cost of reproduction. It has gone down. There is nothing else in copyright law that has that parameter. It is dependable. You can concentrate, you can get greater efficiencies, and this is an example of hardware efficiency. And the question that I want to sort of think about, if you think from a legal point of view, let's take the language we have up there, because you were saying you don't get to the language. And you say, is it public if it's in your room? And you feel in your house, you feel comfortable that it's not public. If I'm in my house, nobody else is in my house, the Betamax is in my house, and the antenna is on my house. Everything feels hugger-mugger and localized. What changes if we don't replicate the costs? There are net welfare gains. What changes that's relevant to any copyright, relevant to statute? Nothing. Relevant to any copyright policy? I would say nothing other than you don't want to stand in the way of things that make it easier for the consumers to access the works the statute's supposed to incentivize the creation of.
Well, I guess I would suggest that the thing that's been added is another player. Whereas, so in the Sony Betamax case, you had a manufacturer who put a, what was ended up calling under a patent analysis, a staple article of commerce, was sold to a user, and the user took it home and did what they did with it. I think what we're seeing now is a collision of what people can do at home and what the third-party providers are providing. Are they providing only a tool, or are they providing a service in which they stay involved and have some responsibility under the law? And we're going to either the Supreme Court's going to decide they do, or it's going to be Congress that goes back and says, well, in this case, like they did in the retransmission era, back when they changed the statute to say that it's covered. And I do think there is a big difference here when there is that third-party player involved. And my understanding of Cablevision's argument, and I think in the Aereo case, Cablevision has taken a really kind of nice in-between position that the Supreme Court's going to be really looking at pretty carefully. But my understanding of Cablevision's position, sort of writ large, is that they are providing a tool when they provide a DVR up at the head end. But Aereo is not just providing a tool. Aereo is providing a service where they take a big pool of content from over the air, and then they transmit it to people who ask to have it transmitted to their homes.
Yeah, I mean, I'll speak to that. I don't know that I've ever found that service versus tool thing is doing a lot of work. I mean, an internet service provider is an internet service provider, but that's like a paradigmatic example of something under the DMCA whose liability is only analyzed as a tool that customers use. So the real question is, what is the service you're providing? Is it offering transmissions to everyone, or is it providing a service where people can make their own recordings and just transmit it back to themselves? The other point I wanted to make, just in response to David's comment, and this comes back to the thing I said at the beginning about this being a case about not only text but also context, is that the argument that, look, you can do this with your own personal antenna, just put it up on your roof, and this is the same thing, that is a good persuasive argument, and the Supreme Court accepted that exact argument twice. And that definitely does get you 99% of the way there. And then the problem is that last 1% is the statute Congress passed to overturn that exact rationale. And so,
not remotely.
well, yeah, I mean, and you can take that up, but I would say that on a common sense view, what the service area was providing is enabling you to retransmit television.
David, I just want to push you on I mean, I enjoy disagreement on panels. I want to push you on how much work the fact this is free over-the-air broadcast is doing in your analysis, how much work that this has to do with transmission. So one way of butchering your argument is, if technology makes something more efficient, then it's not illegal under copyright, which would be wonderful if that was the whole statute, because it'd be very easy to teach, right? And so what about peer-to-peer, right? Was the Grokster case wrongly decided? Because that was all sorts of efficiencies, right, of taking these copyrighted works and pushing them all over the place.
I'm going to have to bring my partner Mike Page in to talk about Grokster. So it's a different right and it's a different structure.
Okay, so performance really is part of what
I think, I mean, although I'm sympathetic to the analysis David's offering, I do, if somebody from ABC were here, I think here's the argument that you would hear is, well, this is free over-the-air television. It's not free, it got paid for. It got paid for by advertising under a set of assumptions about who the audience would be. And the advertisers pay based on an assumption about that audience, right? And Aereo comes and disrupts that by creating a larger audience, but in the course of doing that, by collecting money from doing that, just as community access television and then Cablevision did. And Congress made the view that when a commercial intermediary extends the audience for broadcast television, that intermediary ought to pay something to the content creators in the course of delivering that service. And so cable television pays that under a statutory license. And why shouldn't this commercial intermediary, who's extending the audience for broadcast television, also pay a chunk of change back to the broadcast content creators so that there's a level playing field between satellite, cable, and now Aereo?
As a purely doctrinal matter, I think you're conflating distant transmission and purely local, just in terms of the fees. But the
question is public performance before we get to the compulsory license question.
When you talk about what the statute attempted to do and what the statute says, I think you come down to transmission, and I agree with Robert on that, and you come down to public. And 2 and 1, when you read them together, they refer to things that are not your living room. It's very difficult to get your living room out of 2 and 1 unless you have an aggregation principle. And the aggregation principle is why people are talking about the cloud, because all of a sudden the legality of me making the copy in my living room depends on how many other people are making how many other copies at or near, it's asynchronous as the statute says, the same time. I don't think you can draw the line by saying service versus hardware. ABC broadcast content back in the day when we had 3 channels and we would hold our antenna up to try and get better reception. I actually did that. ABC didn't sell TVs. ABC didn't sell antennas. Tell me at what point it becomes a system. We're just talking about aggregating inputs. The relevant issue in Sony, which is still the relevant issue, was whether using whatever means the consumer has at their disposal, the consumer can make a choice to make a copy the consumer alone can access, so they can shift in time, so they can rewind, which you can't do in a pure transmission, so they can store and watch later, which you can't do in a pure transmission. And if the answer to that is yes, which I think it has to be given the sort of old school broadcast bargain, then no distinction based on the number of inputs is going to hold up, because it's always going to be in flux, and you're going to come back to the same principles. Who's taking the volitional act? How many people have access to the copy that facilitates the viewing after that volitional act is taken? If you're there, then you can deal with public. If you're not there, you are incapable of dealing with the concept of public in a way that matches up with the statute. And what I think Cablevision probably did, I wasn't there at the time, what lawyers everywhere do, what my law school did back when it was trying to figure out what it could do under the Bakke decision, is they read opinions, they say we have guidance, and they try to follow the guidance. And the unusual thing I have found is that the dime slide that you put up, and I do want to compliment your animation, because I could never get that triangle to actually fragment. You look at that and you say, okay, did a lawyer look at this and read the opinions and say, this is the guidance the Supreme Court has given us, let's try and follow that? And I don't know what you're supposed to do if you're not supposed to do it. You're supposed to ignore it? That makes no sense to me whatsoever. So the notion that the court articulates principles that elaborate the statute and lawyers read them and they advise business people so that we can try and adhere to the statutes in the way the courts have interpreted them seems to me ordinary science. It's the way things do and should work. So you asked about the third one. I wanted to loop that in. I thought.
Good. No, thank you. So before we transition away from the case itself, I'm going to ask you all, and my guess is you're all going to dodge this, but maybe not, to kind of make your public prediction now. And I want you to try and predict what the court will do, not what you hope they'll do or what would be the right thing for policy. I want you to actually try and count the votes and decide what the court's going to do. Michael, I'll go to you first.
Okay, I forgot. I have a disclosure that's. I was on a brief in the case, but it only argued that international law does not dictate the result in that. And I think we're going to win on that, since the SG at oral argument agreed with that proposition. But no, I think Aereo loses, and I don't think it's that close. But could be 6-3, but more likely 7-2, 8-1.
Okay. And reverses Cablevision along the way, or leaves it
No,
untouched for now?
I think I'm not sure about that. I think the way they write this, I can't predict it. It's because I've been trying to. I think there's one path to writing this that might make sense, but I don't think they're going to take that.
Okay. Lance?
I haven't thrown in a disclaimer yet, and everyone else has. So I'll say we represent my firm has certainly represented parties on all sides of this issue at different points. So these are absolutely my own thoughts. I think that when it comes right down to it, that the underlying statute here, the language is problematic. And I completely agree with David that this is what companies do, especially emerging companies. They look to the statute, they look to the case law, they get the best lawyers they can, and they make a decision. David's responding in part to this argument that some of the petitioners and the amicus on the side of petitioners have made, that it's a Rube Goldberg type device set up to evade copyright law. But I agree that that this is what companies do. But given that the statute itself is as difficult as it is, I don't think the Supreme Court, there's no eye of a needle for them to thread here. Whatever decision they take is going to have unintended consequences one way or the other. But I tend to agree with Michael that the Supreme Court is likely to find that Aereo's system is infringing. I don't think they will overturn Cablevision, and I think they'll find some middle ground so that in the future, especially when we're looking at cloud-type devices, that this becomes more of a fact-based analysis where courts are going to have to look at sort of the spectrum of how involved the third party is versus how much of it is volitional on the part of the consumers.
From my perspective, obviously, a lot of interest in how the court decides the case, more so than who wins or loses, right?
Yeah.
And I would say that we went in with the hope that it would take a particular approach, and by the time argument came along, I think our comfort that the Supreme Court would go that way increased a lot. And I think two factors that drove that were, one, just the willingness of A, the government, and B, the broadcasters to back off some of the more extreme positions they took in the brief. And I think both the government pretty explicitly, Malcolm Stewart went on the record and said that he thought the Cablevision decision had been appropriate. And so that, I mean, that was a very big boon, I think, to the position we were taking. And the petitioners, although I don't know that they said that strongly, certainly made clear that they weren't attacking that decision, just some aspects of the reasoning as applied to Aereo's case. And then beyond that, too, you never know how the Supreme Court is going to treat Court of Appeals opinions. In some cases, they spend 3 seconds with it and say, oh, well, it's not our case, so who cares? But much to our, we like the fact that some members of the court, especially Justice Kennedy, seemed to...
Assume this is our opinion.
Our case, yeah.
And Paul Clement didn't do much with that question.
Yeah, and so I think there was some, and I mean that, I imagine is a combination of one, Judge Walker, when he wrote the opinion, I mean, he's no ideologue, and so whatever you say about the reasoning, I mean, it wasn't an out there decision, and so I think there was a level of comfort with the Supreme Court about the legal analysis, but then combined with that too, I think that the Supreme Court got that there was a lot of reliance interest on that decision, both not only by Cablevision, but also by other cloud computing technologies. And so I think that those two things combined to put that Court of Appeals decision into a situation where they're willing to give it a lot more precedential weight than it would get in some other case.
But do you agree with your two predecessors that Aereo still might lose, despite the fact that they may not overturn Cablevision?
Yeah, of course.
Okay. Well, okay, Mike, is the long question. Do you predict that will happen?
I think on balance, I would expect so, and I think it's just because, and again, I don't take issue with the notion that lawyers in good faith design their program or their systems to comply with the copyright law, and that there's nothing wrong with that standing alone. But on the other hand, having done that, you still are going to be questioned about how different is our system from the systems we're relying on. Are those systems different in a way that is potentially different under the statute? Are they different in a way that's matters in terms of the history behind the statute? And I mean, the history behind the statute, I think, is just a big problem for Aereo in this case, because Aereo fairly viewed as a successor to cable systems, and it does it through a different technology, but it is that kind of service. And I think what convinces the Supreme Court that the RS-DVR is different, that it's very much the successor of a different line of cases, or a different line of technologies. It's the latest thing in the VCR and the DVR. We have our own content provision service where Cablevision has a cable system where you can get the content at your choosing. And so the RS-DVR is a meaningfully separate recording and playback service in the way that Aereo's isn't. I mean, Aereo has its own DVR functionality, but it's not like that system is somehow separate from the rest of what it's offering. I mean, it's trying to rely on the system to justify the entire system. And so the fact that you also offer DVR functions doesn't somehow give you an excuse to offer live transmissions that anyone can watch whenever they want. And in that sense, Aereo is relying on a precedent to make a quite different argument than the one it was pressed into service for originally. And in doing so is running up against a historical context that I think is going to give the Supreme Court a lot of pause before they're willing to take that step.
So our prediction market is saying Aereo loses, David. Are you going to?
I'll just note for the record my disagreement with a large fraction of what Robert said. Disclaimed as I am, I don't have a prediction. Let me offer an observation on what the Supreme Court does in IP cases. Let me toss out a couple of hits for your remembrance. Lotus and Borland, remember that one? That's a Boudin concurrence, a very, very, very well-regarded judge out of the First Circuit. That's the copyrightability of menu commands. The current wave of patent cases, which we're all still enjoying, they have a similarity to them, most pronounced in eBay, and the similarity, and you get this, with the exception of Grokster, you get this in a lot of cases. You get the court taking an issue, you get an opinion that recognizes the high degree of complexity and reliance interests everywhere we look, and then you get an opinion that says in substance, wow, and here's a statute. Go forth and read it. Thank you for calling. And Quanta is like that. There are a bunch of others like that. I don't know, I'm not going to try and predict what it entails in this case, but I do think that it will be a cautious opinion however it comes out, because, and actually on my roster, Lotus and Borland, Sony, Justice Blackmun's papers tell us, was about to go the other way. It was a last-minute switch, and the reason the Blackmun dissent is so long as it was a majority opinion. It now, nobody on this panel has taken up my invitation to go trash that case. It now is just stone cold bedrock common sense. And it's interesting that something could be that close and then with the arc of technology over time become considered to be a very good moment in the history of statutory interpretation. So I think it's very difficult to predict when you've got some of these close calls. I do think that it will be a cautious opinion for the reasons I said.
So that's a perfect segue because let me cleanse our palate of the statute and put this back on the screen. Okay, so
Does that mean we get a drink?
what's that? Yeah. So this was the Rube Goldberg point that Lance has commented on. David has teed up nicely, but I want to hear from all of you. So one thing that struck me as I read the varying briefs was the not only the description of Aereo's technology, but the description of this entire mode of innovation and whether it's fair to call it innovation at all. So on the petitioner side, you really have them saying like this is underhanded legal engineering to evade the clear strictures of the statute. I'm grossly misrepresenting. And on the other side, the argument is no, this is what copyright law is all about. Copyright law like puts up little boundaries, and then they say go forth and innovate, and just don't trip over these lines. And so either as kind of lawyers advising clients about the next great thing, or as kind of, detached commentators looking at what Aereo did, which way do we see this? Like, what do we think of this innovation? David, you've already expressed a lot of opinions on this, so I'll start with you, like in this kind of more directed form. What do we think about this? Is this celebrated, regretted, something else?
I don't think it's either. I think it's just reality.
Yeah.
The purpose of the Copyright Act is not to allow my students to amortize their loans, although that's a nice byproduct. It's to promote the creation and dissemination of works. The thing that I find interesting is the Rube Goldberg line of argument. It is, to me, a distortion of the intersection of two things. Lawyers didn't invent that board. Lawyers didn't invent the ability to create antennas that small. None of this comes out of the law. What we do is translate, and if we do what we do well, we are in a sort of, in my case at least, very low rent, Steve Jobs-ish way. We are trying to meld liberal arts and science, and we are trying to allow those two worlds to speak to each other and make sense of each other's norms and practices. And so when we get the capacity to do something like this, and we have legal inputs on one side, and we have people who say, wow, this could be really cool, you don't have to load up your TV stand with hardware. You don't have to push all the intelligence to the end. We can do this desirable thing at a lower cost. Is that cool? Can I do that? What do I need to do that? That's a very desirable conversation to have happen because it is the way in which innovation on the science side can be brought to market and deployed in a way that actually helps people. And we're sort of at the crossroads. Ron Gilson said years ago, lawyers are transaction cost managers. We are trying to find the path in which this very desirable thing can happen. And I don't know if that's good, bad, celebrated, not celebrated. I think it's useful. It's not as useful as a new cancer drug. It's more useful than tractor pulls. Somewhere in between. I don't know.
Michael.
I want to say two things, and one to the students. So I actually, Chief Justice Roberts seemed to take on this Rube Goldberg point, and I actually somewhat take offense with that line in that Aereo really did, it restricted its service to within the Second Circuit where there was an appellate binding precedent that one copy, one transmission was legal, and yet it's still being treated as avoiding copyright. And what's interesting is Cablevision did the same thing. Cablevision chose an inefficient engineering solution. Let's make lots of copies of DVR so it will look like a DVR at the home, as David says, and the court accepted that. We could have just had one copy, but then Cablevision would have lost. If they were transmitting from one copy, they would have lost, I guarantee that. So let's have each customer make their own copy, and we'll store it. And so Aereo does the same thing. I think this is a point about perception. You couldn't see all of those copies on Cablevision's server, so the idea that there was a Rube Goldberg engineering design was hard to convey, whereas this looks like a Rube Goldberg, and so it's getting treated like that. But that's just the difference between tax evasion and tax avoidance. Companies do all of these weird corporate structurings merely to avoid paying income tax, and we call that clever lawyering and clever business design. And here it's being treated as a form of piracy when it's exactly the same behavior.
So I want you to take the next step from it's exactly the same behavior to, and it's is this the point of copyright? I mean, is this same sort of thing? What adjective would you put on this kind of innovation?
I think, okay, so this is I want to throw something to the final panel of the day, the business panel, because I think we're in the middle of this negotiation over video on demand, right? So there are enough of us in the room where this is the magic bus moment, right? So we, the consumers, we're Roger Daltrey, right? We want our media anytime, any place, wherever we are. I want it, I want it, I want it. And the content industry right now, they're Pete Townsend. You can't have it, right? And because we haven't figured out a business model to make as much money as we make now, and we can't do it, right? So is this innovation? Well, sure, in the sense that it is proving that people want to watch TV on their mobile devices. They want to be able to watch the Super Bowl while they're out and about and have a mobile phone. And this is one way to do that because the copyright owners and the broadcasters are not providing that service yet. So I would say, yes, this is innovation because it's meeting the consumer where they want to be, and it's pushing us along. But this is part of a piece. I mean, the whole SOPA and PIPA, let's try to break the internet to shut down this video on demand until we figure out the business model is part of this same story.
Lance? I mean, your clients of your firm are gonna ask similar questions, right? There will be other parts of copyright law that'll necessitate engineering around.
Right, and again, we see it from both sides. I mean, and the content providers have an interest in monetizing the content in every way they can, and here I think one of the sort of instinctual reactions to the Aereo service is that there's this step in the chain fostered by a party, and that party is not paying for taking part in that step in the chain. And I think that that's why, to me, although the cloud services can be impacted by this decision, I think most people's instinctual reaction to the cloud services, this is my content. I own this content. I'm putting it there, and it makes no sense for the law to say, just because some service holds 15 copies from 15 different people and then sends them back out to those same people, that somehow becomes a public performance. I mean, it's sort of, again, it's a bit instinctual, and I think that, but when it comes down to what we have to advise clients, I mean, we do exactly what David described. You look at the case law, you look at the statute, and you do your best to advise if they're on the engineering side and they're in its new technology, what can you do to best accommodate the existing law? And if you're on the other side, then you try to determine whether or not what's being done is infringing. I remember one of the very first times I came across the public performance right in a real way was in 98, 99. We actually were asked by some of the broadcasters to look at the TiVo and replay device. And it was really more of a reproduction right question, and that's where we focused by far the most of our efforts. So we were trying to determine how the Sony case fit into the new technology. But one of the things that troubled us then was the performance right, because it's just not clear in the statute. And so you were making some guesses. Aereo had to make those kinds of guesses when they got into this business. They bet a lot of money, and Barry Diller's bet a lot of money on it satisfying the law as it's currently written, and we're going to see what happens. I mean, at the end of the day, if Aereo is not overturned, Congress can still go back in and impose a compulsory license on this type of content, on this type of transmission.
But I shudder to think of how they'll articulate that in statutory text. But, and then Robert, the last on this question of innovation, Michael's kind of put on the table that if we remove ourselves from the public performance question, this is pretty indistinguishable from what your clients did with the DVR in the cloud, that it's kind of separating copies in ways that no efficiency-minded engineer would have done. It's just copyright law that's dictating the engineering.
No, I would disagree with that. I mean, I'll preface this by saying, as I mentioned before, there's nothing wrong with designing your system in a way that complies with the law. And the fact that someone can come along and say, well, I've thought of a different way you could have designed your system that would have been illegal. I mean, you can tell Cablevision that, well, if you designed your RSDVR as basically a video on demand service where Cablevision just makes a single copy of each show and offers to play it to anyone at a time of their choosing, yes, of course, that would be an infringing system if you didn't have a license. And that alone is not a good argument against the system's illegality. On the flip side, though, if you have architected your system in a way that is very similar to something that is unlawful and that you have no real justification for the differences between it, which I don't think is in the case in Cablevision, because that really is a system where the closest analog is a set-top DVR, which Cablevision had already offered to its customers for years, and it was just moving the hardware from the head end to from the customer's house to the head end. Mm-hmm. For Aereo, by contrast, the only difference as I see it is the mini antennas versus the one single antenna primarily. And if the single antenna is infringing, they can argue that the mini antennas makes it different under the statute, but they have to put up with the fact that courts are going to scrutinize that and say, is this detail that doesn't have a lot of significance change the fundamental nature of the service that they're offering? And so while you can design your system to comply with the law, and it's not a valid argument that alone somehow means you're circumventing the legal structure, you still have to put up with the fact that you're going to have to justify to a court why the differences matter, why they change the nature of the service you're offering, and therefore why they don't undermine the regime that Congress tried to apply to cable systems.
So let's open it up to the audience. We've got about 12 more minutes. I've got a bunch of other questions I could ask, but so we've got a call on the statutory interpretation of the Weiser rule. John's going to save me from having to give my little speech. Thank you. The interpretation I was going to give for future panels is if you've graduated, you're probably safe, but we'll still call on you if you raise your hand. But
I'll save the recent graduates
Thank
here.
you. I appreciate that.
I think it's really interesting in this case that we have over-the-air broadcast is kind of unique. You're not paying for a normal viewer of broadcast television isn't paying for copyrighted content. They're getting it for free. So I was wondering if the panelists could each kind of give their views on the equitable concerns of the social contract that we have, which grants that over-the-air free television, and whether or not, Michael, you mentioned kind of the contract there is the broadcasters get exclusive rights to retransmit within that area or they get paid for it. But Aereo does, as I understand, limit the areas where you can get, that retransmission to where you could get it free over the air. So I just wonder, what is that social contract? Because it seems like Aereo is kind of in line with that, just with a new technology.
Yeah, so, and in the advanced questions I sent you, it's a great question. I said that some people feel like maybe we should be discussing this as a telecommunications policy case more than a copyright policy case. And as a center, we do a lot more telecommunications policy than we do copyright policy. So one of the things we think about is the public interest and the fact that you don't need a subscription to collect something like over-the-air broadcast. So should that factor into how we think of the kind of policy question, not the copyright question? And how important is it?
Yeah, I mean, it's very funny, the generational shift. So David and I come from a time when over-the-air broadcast, free content was the way you consumed media. You only had three choices, but it was all free. And the idea that you would pay for content is still a relatively new idea for us, and I'm a Netflix subscriber. But I think your point is well taken, that there is still something about public broadcast that has a special feature because you got these airwaves. I think we are in this long negotiation, right? All of those, if I told you the whole story, but eventually we're going to get a First Amendment case that says that spectrum licensing violates the free speech clause because you're going to have smart radio such that it's no longer a scarce resource, and it's all going to be used for wireless internet transmissions, and all video programming is going to be delivered over the internet. In which case, all of this is going to become obsolete. But it's a long road to that point.
Other thoughts on that? I mean, David, you brought in the kind of free public nature of this, and I think you might have even also talked about the kind of social welfare, the social good.
Yeah,
this.
It was part of my sort of foundational points. If you want to redo the system in which it is a requirement of your license that you broadcast for free, have at it. It's just, you can't both be a doctrinalist and not acknowledge that that's the deal. And that, to me, is why Robert's doing a lot of work on distinguishing the systems. To me, why the license point is totally irrelevant, because it's sort of like multiplying by zero. I've got the right to do this. Well, I've got the right to get the free broadcast. That's actually as old as it gets. It's a lot older than DVR. So if there is a good that is associated with access to free broadcasting, then that good is going to be greater, the greater number of people who can see it. And it's just a measurement problem whether there's a revenue effect from advertising. That's not actually that big a deal, because if you're paying for eyeballs, as Mike suggests, that's, that ultimately is not going to be a problem, I don't think. So yeah, there are a lot of arguments you could make about this case that work very differently in every forum except local broadcast. In local broadcast, the front end is supposed to be out there for you to grab. That's the point.
And Harry Sheridan's panel next will talk about fair use, and maybe some of these issues of kind of the nature of the uses will come up again. Yeah, so we'll go more broadly to the audience.
Can I just weigh in on the
yeah,
policy
sure.
point for a second?
Yeah, while the microphone's walking over, yeah, go ahead.
I mean, there are lots of great policy arguments against the 1976 Copyright Act, and if we were having this debate then about whether Cablevision and other cable companies should be paying fees to copyright owners to retransmit content that was publicly available, those arguments were made, that debate was had, and so I guess there's still some value in debating the wisdom of the 76 Act, but it's important to understand just how far removed that is from the actual real world case that the Supreme Court has to decide.
Oh, no, the hand. Oh, you got a question too, Daryl? Why don't we do one more student question, and then we'll go recent grad question, right?
Sure. I wanted to know how important access was, because with what Aerial's doing, they're giving access to people who normally wouldn't have it. For if I wanted to watch something live on Fox, I wouldn't be able to watch it on my laptop right now. Whereas opposed to the Betamax case, it was something you already had access to in the format that they wanted you to have it in. And Aerial seems to change the format, where instead of watching it on your TV, you're watching it on your laptop, on your mobile device, and things like that. So how important is that for copyright purposes, I suppose?
Yeah, and again, there's a little fair use in that question, or a lot of fair use, so we'll leave some of that for the next panel. But if you want to weigh in briefly on this idea,
don't think
it's not time shifting, right? It's device shifting.
I don't think it changes the format. I think it changes the hardware. But that does not matter. That should be completely... copyright should be completely agnostic with respect to that question. The hardware changes and you get new functionality. You get to stop, rewind, you get to save. Those are not things that you can normally do. It absolutely increases access in the sense that it allows you to not have to lug around antiquated hardware. And it allows you to take advantage of relatively efficient hardware.
And I will add to that it is very much a fair use question, but it also points up the importance of deciding whether it's Area or the customer who's doing the recording, because in Sony, one of the critical reasons why Sony said that was consumer fair use was that they said when a consumer is the one doing the recording, that counts as a non-commercial use. And so if, for Area, for example, it's the case that the consumer is the one doing the transmitting or the recording or whatever, perhaps that would map on. On the other hand, if a court were to rule that Area was the one doing it, so it's a question of direct liability, then there would be a strong argument that the fair use analysis would be different from how it was in Sony, because that first factor, whether it's a commercial service or not, really depends upon who you think is the one doing the otherwise infringing act.
So, Coben, up on the wings, you still have your question? Yeah.
Hi, Linda Kinney from the MPAA. Since you didn't have any copyright owners on the panel, I thought I would mention just a couple things to the students. I think this is an example of a case where telecom policy really overlays copyright policy. And so for those of you that are in this area and looking into sort of going into online and high tech and innovation and trying to interpret the law, I don't think you can do it in isolation. So I would beg to differ. The only language that was actually up on the screen was the Copyright Act, not the Telecom Act. And if you read the two of them together, then it's pretty easy and I think quite obvious what the outcome would be. There are very important differences between Aereo and any other subject that was discussed today. I mean, for one, again, in the Aereo case, the intermediary did not pay for the content. Not true in Cablevision. Cablevision did pay for the content. And there are lots of other similar situations like this. Dish's Slingbox comes to mind. There are quite a few things in this area that actually look at those two issues. So I think you have to look at both telecom and copyright law and not just read one. I think the other thing is don't throw common sense out the window. In this situation, it's pretty obvious that cable television providers all have to pay to retransmit broadcast signals. Satellite providers all have to pay to retransmit broadcast signals. It's not possible, given both statutes read together, you would ever have a situation where a party should be able to retransmit broadcast signals and make a profit without ever paying for the input. And I think finally, the bottom line again, I think the third component and the reason why that's the only outcome to me that would be obvious is that it undermines the intent of Congress. And I think this was a point that Paul made, and Michael Carroll also made the point that the broadcasters actually, the way the entire broadcast system was set up, I know one student talked about the social contract, is again, that broadcasters would make their money off the number of eyeballs. When you have an intermediary that intercepts the eyeballs and then transmits it to an unlimited number of eyeballs that nobody can ever count, again, that gives you a signal that that's not permissible under the Telecom Act, per se. So
I mean, just two, I welcome the intervention. I mean, I will say two things. You said Cablevision paid for the content. I think some of the content industry was alleging they didn't pay for this use of the content. I mean, they were trying to extract another rent from this. So I'm not sure they would all agree, like everyone in content would say Cablevision paid up. And then the second thing I would say has left my mind. Okay.
They will all agree
Yeah.
that area did not.
Yeah, and so you must have been heartened by the very beginning of the oral argument where Justice Sotomayor launched right into, aren't they a cable company? And again, Paul Clement, and who am I to second guess Paul Clement's abilities as an advocate, kind of bungled that question. He just refused to engage with it. Maybe there was no good answer. Justice Breyer also kind of had some sympathy for this idea that maybe they're just a cable company within, you're right, a part of the definition I didn't put up there.
But they're not a cable company under the Act.
Yeah,
That was Sotomayor's question. But you're just saying, in terms of this common sense analogy, they're doing exactly what the cable company. Anyone else have a quick response?
Well, I just add to the common sense analogy.
David, I think,
Yeah,
is
probably.
looking up because
Let's respond the most.
you don't pay for local retransmission.
Yeah, no, if that had been on the panel, that would have been great. I would have had time to respond. Students read Section 111 of the Copyright Act. I would be interested whether it's the MPAA's actual position that end users should be required to pay for local broadcast television.
First of all, I'm actually here. I'm not like you, disclosure. CPA's position. What I am saying, however, and that statement has nothing to do with what I said. End users would not pay for local content. That's never been anything. I think as a practical matter, you have a broadcast industry that is built on, they measure the eyeball through Nielsen ratings, so they are getting that income. So there's no end user would pay for over-the-air broadcast. They are paying for their time because
did drop
they.
a footnote that said they had a deal with Nielsen in the works, and they were going to count all the viewers. I mean, again, it was just this little footnote thrown in, not necessarily in the record. I don't even know below, but they added it at the Supreme Court.
Right, because I think that's the problem with their entire service is they've been reselling this without ever counting the eyeballs, which is the fundamental basis of the broadcast business model. So I think that's a real problem with this case, and to the extent that somebody, an entrepreneur, is coming to any of you in this audience and asking, is this something that's legal under the Act? Again, I guess I would just say there are a number of things that you have to look at, and just reading one statute in isolation or without thinking about the broader context is probably not doing you or your client any good.
Time for maybe one more really quick question. Let me ask one more quick question myself then. And you guys saw this coming. I put it in my email. So we've got the great Copyright Act reform, the next great Copyright Act. Is that what we're calling it now? Where we're going to rewrite the whole thing. And one law professor provocatively sent to a list the question, why do we restrict copyright to public performances? Why don't we extend copyright to private performances? Back in the day, that wouldn't have made sense because it would have required breaking down people's bedroom doors to see what they were reading. Today we can, or not reading, I guess, but what they were watching. Today we can do it just fine, right? We can monitor everything. I'm a privacy scholar, not a copyright scholar. Does anyone here want to stand up for that
Well,
argument?
in Europe, that principle to some extent exists because there's a blank media levy, right? The idea is that copyright owners should be paid for those private performances. We won't directly monitor, we'll just indirectly charge.
So if you buy
on the-
blank CD-ROMs or maybe even
In
USB
Europe,
thumb
a
drives,
tiny
yeah.
chunk of change out of that transaction goes into a pool of money that then gets paid to copyright owners on the assumption that you're going to burn somebody's copyrighted content.
Yeah, so I'm not asking about the current statute at all. As a matter of sound policy, innovation policy, incentive policy, whatever you want to say, should we extend the copyright to private performances?
Not at all.
No. Either of you guys want to?
Seems a little extreme to me. I mean, the copyright has to strike a balance between the interests of the authors of works and the consumers of works, and that is struck, for example, by the limited times clause. I mean, if by the same
There's a
argument.
limited times clause?
Yeah.
Yeah.
I thought we had written that out, but not yet.
But
No,
the point being, the copyright owner, it is hard to argue that you should be able to collect a royalty every time somebody reads a book they previously purchased or sings in the bathroom a song that they heard on the radio or something. I mean, there are those are just really extreme versions, and you have to strike a balance, and it kind of has to be built on social expectations and common sense. And I think that one is over the line.
Last comment.
All of Aereo set aside, forget this case and just focus on the policy question. I'm going to channel my friend Randy Picker at Chicago for a second. One of the artifacts of technology, one of the byproducts, is that we are much more able to regulate access. And Randy always says copyright is a use and a distribution regime, not an access regime. And it cashes out in price discrimination, and Julie Cohen has this, articles about the perfect curve. But there are reasons to think that copyright is not the right tool to go after every problem, particularly when technology creates a universe in which access and per access pricing is much more feasible than it was in the past. The 76 Act was the product of something like 12 years, continuing resolutions, kicking the can down the road until they got this thing. I don't think this is a risk that it's going to happen in the near future, but the interesting thing is going to be the degree to which it can be technology neutral so it becomes obsolete a relatively long time after it's passed rather than immediately.
So I'm going to unilaterally decide that you get 2 minutes back that we just took from you. So be back in your seats at around 3:12. But before you get up to stretch your legs, please join me in thanking the panel for their wonderful.
Good job.
Christian panel.
It was fun.
Yeah.
Michael?
Hey, it was fun.
Thank you.
Well done.
Yeah, really appreciate it.
My pleasure.
You've got a fun.